Good afternoon, everyone. I would like to call to order this public hearing of the Committee on the Judiciary and Public Safety. The time is 1:01 p.m. on Thursday, June 8th, 2023. We are conducting this hearing virtually and streaming on the DC Council website and YouTube at CM Brooke Pinto. I am Councilmember Brooke Pinto, representing Ward 2 and Chairwoman of the committee. The purpose of today's hearing is to discuss the following bills. First, Bill 25-42, the Grounds for Divorce, Legal Separation, and Annulment Amendment Act of 2023, and Bill 25-44, the Vulnerable Youth Guardianship Protection Amendment Act of 2023. Bill 25-42, the Grounds for Divorce, Legal Separation, and Annulment Amendment Act of 2023, was introduced by Council members Nadeau, Louis George, Robert White, Chairman Mendelson, and me on January 19th, 2023. The bill would first eliminate mandatory waiting periods for divorce and legal separation in the district, and second, expand the relevant factors that a District of Columbia Courts Family Court Operations Division may consider in awarding alimony or distributing marital property to include evidence of an intrafamily offense. And third, authorize a family court judge to award exclusive use of a family home or dwelling to one party while divorce, legal separation, or annulment proceedings are ongoing, regardless of which party has a property interest in the dwelling. District law currently mandates that parties seeking a divorce must demonstrate that they have lived separate and apart for a 6-month or 1-year period prior to commencing divorce proceedings. Relatedly, for legal separations, if the parties do not mutually and voluntarily agree to live separate and apart, then they are required to show that they have lived separate and apart for 1 year prior to seeking legal separation. It is unclear what the legal or practical rationale is for establishing these mandatory waiting periods. These delays, importantly, can put survivors of intimate partner violence and domestic violence at particular risk, forcing them to wait out the requisite period with a spouse who poses a risk of violence. As noted, this bill would eliminate such waiting periods. Second, the bill also adds an important element missing in the district's family law. Currently, when district family court judges determine alimony or property allocations in a divorce proceeding, the court lacks authority to consider as a relevant factor evidence of intrafamily offenses, such as domestic and intimate partner violence, in addition to considerations of potential income and income changes. As a result, the law fails to consider the meaningful financial and personal costs that stem from intrafamilial offenses. Studies of the U.S. economy have shown that annually domestic violence results in 8 million days of missed work days. This bill would remedy that omission by providing the court with the authority to consider intrafamilial offenses like intimate partner violence and domestic violence when determining alimony and property calculations. Last, this bill authorizes a district family court judge to assign exclusive use of a family home or dwelling to one party during pending litigation. While current district law allows family court judges to render temporary determinations regarding child support, alimony, custody, and other matters, it does not authorize the judge to accord exclusive use of the family home or dwelling. This change will provide needed flexibility for judges to ensure, for example, that victims of domestic violence are not forced to reside with their abuser when they do not personally have the means to secure alternative housing. Today, we will also discuss Bill 25-44, the Vulnerable Youth Guardianship Protection Amendment Act of 2023. That legislation was introduced by Council members Nadeau, Allen, Robert White, Gray, Bonds, and myself on January 19th, 2023. The legislation would provide critical support to undocumented immigrant youth, one of the most vulnerable populations in the district, who have suffered from abuse, abandonment, or neglect. The legislation would expand the Superior Court's jurisdiction in 2 important ways. First, it would allow the court to issue findings necessary for immigrant youth up until the age of 21 to petition the federal government for special immigrant juvenile status, a humanitarian visa covering abused, neglected, or abandoned immigrant youth under the age of 21. If approved, those holding SIJS would be authorized to work, maintain a social security number, and receive assistance for housing and education. This is a largely technical fix, aligning district and federal law to provide the court with the jurisdiction necessary to support these youth petitions for SIJS. Second, this legislation would authorize the DC Family Division to appoint legal guardians to a newly recognized legal status of vulnerable youth, an unmarried non-citizen who is under 21 years of age. This new class covers immigrant youth up to 21 years old who are not already in Child and Family Administrative Services custody, without the need for ongoing supervision from district agencies or the participation of the Office of the Attorney General. Likewise, youth already under CFSA custody and minors under 18 will not be adversely affected by this legislation, as it neither modifies nor repeals existing law. Guardians constitute invaluable care and support for vulnerable youth as they pursue their course, especially for immigrant youth who will be petitioning for SIJS and who will need support and guidance in negotiating with the legal system. I want to especially thank my Ward 1 colleague, Councilmember Brianna Nadeau, for her leadership on these two important issues and introducing these bills that we are considering today. For today's hearing, we're going to follow the committee's normal practice and hear first from public witnesses. I will note there are no government witnesses for either bill today. And so public witnesses will have 3 minutes to present their testimony, and those who represent organizations will have 5 minutes. Before we turn to our witnesses today, I want to turn to my colleague, Ward 1 Councilmember Brianna Nadeau, for any opening statement that you may have. Please go ahead.
Thank you so much. I apologize. I'm hoping the sound is okay. I'm taking a break from the Ward 1 senior dance to join you. So it's very festive around here, but I am just so grateful, Councilmember Pinto, for you holding this hearing today on two bills that I introduced. The first bill, the Grounds for Divorce, Legal Separation and Annulment Amendment Act of 2023, was originally introduced as a Lane's Law for a Ward 1 resident and survivor of domestic violence. Because she was the top earner in her marriage, her abusive husband dragged her to court to force her to pay spousal support, healthcare costs, attorney fees, part of her government pension, and other fees to her abuser in the divorce proceedings. As more women become top earners, some are forced to pay their abuser's alimony and other legal fees. In January, I reintroduced this bill to address feedback since the 2019 hearing. Under current DC law, those wishing to divorce are required to wait 6 months or 1 year, even if both parties agree. My bill changes that by eliminating that oppressive waiting period. The bottom line is this: district law should not be the thing holding people back from leaving abusive relationships. So let's change that. While we're gathered today, I also want to take a moment to honor the life of Andrea Gleaves, who passed away recently from cervical cancer. She was a force to be reckoned with. She was an advocate, an ally, and a friend. She was a fierce advocate who fought for domestic violence justice and true equity for marginalized people. So I hope others will join me today in honoring her memory by continuing her fight for a world free from violence and inequality. Second bill today that I want to speak to is the Vulnerable Youth Guardianship Protection Amendment Act of 2023. Turning 18 for most young people means newfound freedom, being able to vote, graduating high school, and starting their adult lives. But for some 17-year-olds living in the district, turning 18 means the opposite. They'll be prevented from accessing federal services like applying for financial aid to pursue higher ed, and prohibited from working in some instances. In the worst case scenario, they might even be deported to a country they once escaped from in search of safety. This legislation changes that. It would rectify the discrepancy between federal and district law that deprives vulnerable immigrant youth from gaining permanent status and the humanitarian protections that Congress intended for them. Would ensure that immigrant youth can access special federal immigration status and pursue education, work, and fulfilling lives like other youth in the district. The bill would also allow courts in the district to appoint a guardian for eligible youth between the ages of 18 and 21, a prerequisite for them to obtain protection for young people who have been abused, abandoned, or neglected in their country of origin, called a Special Immigrant Juvenile Status visa. Because DC courts do not currently have this authority, young people who are otherwise eligible are precluded from seeking it. The legislation would allow district courts to appoint legal guardians for youth something that has been shown to help reduce the risk of further abuse and provide ongoing support while they enter young adulthood and integrate into the community. This is very much aligned with this city's commitment to welcoming immigrants to live here in safety and with dignity. But this is as much or more so about how we treat our young people, about the welfare of the children and young adults in our care, something that has been a core priority for me since my earliest days as a council member. As the nation's capital, let's continue to be a model and strengthen our efforts to be a place where youth, including immigrant youth, are safe and can access the human rights and opportunities they need to help them toward a bright future. I look forward to working with my colleagues to pass both of those critical bills. Thank you, Councilmember Pinto.
Thank you so much, Councilmember Nadeau, and I hope it's great over there at the senior dance. Thanks for joining us today. All right, we are going to call witnesses for our first bill today, Bill 25-42, in two panels. So I'll call the first 5 witnesses first. We will hear from Julia Ward, staff attorney, the Domestic Violence Family Law Unit and Immigration Project from Legal Aid. Second, Michaela Deming from the DC Coalition Against Domestic Violence. Third, Aida Vindel from DC Volunteer Lawyers Project. Fourth, Elizabeth Selmo from Bell Desmond Tucker Lifer Fidel LLP. And fifth, Melissa Millar from SEDEC DC. You all a moment to join. All right, and when you are ready, Julia Ward, please go ahead.
Good afternoon, Council Members Pinto and Nadeau. My name is Julia Ward, and I am a staff attorney at DC Legal Aid. I am here to testify in support of the Grounds for Divorce, Legal Separation, and Annulment Amendment Act of 2022. This act encompasses needed reform to the district's current divorce laws, which restrict access to divorces and do not provide enough protections to domestic violence survivors. We ask the council to approve this bill and would like to highlight 3 aspects of the act that will greatly benefit district residents. First, the act removes problematic and paternalistic waiting period requirements for divorces. Under the district's current laws, parties are subject to a 6-month separation waiting period prior to a divorce being granted if both parties consent to the divorce. However, if one party withholds consent to the divorce, the waiting period is 12 months. The court determines satisfaction of the applicable waiting period by hearing sworn testimony about the length and continuity of the separation, including inquiring about when the parties last had marital relations. This means that parties must testify under oath in open and public court proceedings when they last had sexual relations with their spouse. Not only is this invasive and complicated for the court, but it is needlessly re-traumatizing for survivors of domestic violence whose abuse often encompasses some form of sexual violence. The act removes both the aspect of consent as well as any separation waiting period. These changes allow parties seeking divorces to be the ones who determine what is best for themselves and their families on their own time frame. Second, the act enhances the protections and available forms of relief for domestic violence survivors. Most significantly, the act's elimination of a separation waiting period and the removal of any consideration of consent allows survivors to leave an abusive marriage at any time with or without the consent of their abusive spouse. Legal Aid has represented many clients who were forced to wait an entire year because of their spouse's lack of consent and ultimately sought civil protection orders because the violence escalated during that period of time after separation, but before they could seek a divorce. The act's elimination of separation waiting periods is a concrete step towards allowing people to move safely away from abusive relationships before violence escalates and before more severe, sometimes criminal, court intervention enters the lives of the parties. The act also adds language that states that the court shall consider evidence of domestic violence when determining alimony and distribution of marital property or debt, which is consistent with the court's current practices. Additionally, the act explicitly states that the court may award exclusive use of a residence to either party during the pendency of the divorce proceedings. Explicitly highlighting this option for relief in the domestic relations branch will allow domestic violence survivors to request this relief without having to file for a civil protection order. This is an incredibly important option for survivors who can no longer safely live with the other party, but who may not want to file for a civil protection order because of its potential interactions with the criminal legal system or for a myriad of other reasons. Third and finally, the Act simplifies the previously complex divorce process for both litigants and the court. The vast majority of litigants in the domestic relations branch, more than 83%, are unrepresented. The current divorce process is confusing and burdensome for them and leads to congestion in the court dockets. Litigants often file too early, only to have their cases continued or dismissed and refiled later, or they don't understand which waiting period applies to them or whether their spouse will consent. The separation waiting periods also cause delays in final resolutions when parties have reset the clock by engaging in sexual relations while their cases are pending. At Legal Aid, we field countless inquiries on these issues from confused and frustrated litigants. The Act's elimination of the separation waiting periods will greatly diminish this confusion for litigants and streamline the process for the court. Thank you for the opportunity to submit this testimony. We hope the Council will pass the Grounds for Divorce, Legal Separation, and Annulment Amendment Act of 2022 to improve the process for district residents seeking to end a legal relationship with a spouse.
Thank you so much, Julia, for your testimony. Really appreciate your perspective. Next, we will hear from Michaela Deming, the DC Coalition Against Domestic Violence. Go ahead.
Hi, good afternoon. My name is Michaela Deming. I'm the Policy Director here at the DC Coalition Against Domestic Violence. We are the federally recognized statewide coalition of domestic violence service providers here in the District of Columbia. We have 18-member programs. You're going to hear from several of my brilliant colleagues this afternoon. Dedicated service providers in our member programs and at our organization work tirelessly to address the epidemic of domestic violence across all 8 wards of the district. We know here in DC, 39% of women and 25.5% of men have experienced some form of sexual violence, physical violence, stalking, or combination perpetrated by an intimate partner. We're grateful for Council's recognition that changes can be made and should be made to decrease the hardships survivors of domestic violence experience when trying to divorce their abusive spouse under current code. I'm going to highlight hopefully some different things than my colleagues. I want to talk first about that waiting period that you just heard about. We know that the currently prescribed code keeps domestic violence victims in danger and in unsafe living situations longer. It already takes survivors a lot of time and incredible efforts and resources to leave an abusive relationship when they choose to do so. And having those waiting periods and the reset that you just heard about makes that even more difficult. Research has also confirmed that separation is a risk factor for injury and homicide for domestic violence victims. I'll note that the increased danger following separation appears to be linked most closely with when the abuser believes the relationship and their control are truly about to end. Filing for divorce is often that signal for them and has been linked as a precipitating factor for some homicide. Between 2016 and 2020, there have been 68 homicides in DC that were linked to domestic violence. And DV homicides have been increasing since 2018. It's hard enough to leave an abusive relationship and sever legal ties with a dangerous spouse. There's no good reason for the archaic DC law to add this unnecessary barrier, and we fully support the elimination of the waiting periods. I want to talk next about the alimony and equitable distribution factors. Under current law, there is an ability to talk about the reason for the estrangement of the parties, but we know that domestic violence and leaving a violent relationship isn't always linear, right? It isn't always there's one incident and then there's a filing for divorce. We know that sometimes coercive controlling behaviors continue. A violent incident might have been some time ago. And we know that abusers only use the amount of violence that they believe is necessary to maintain control. And so the tactics that they use around domestic violence may change over time and might not be as readily recognizable to a court as a reason for the ending of the relationship. I mention all of this because some judges don't necessarily consider all of that under current law. And this bill would change that. This bill would allow the court to really look at the intrafamily offenses that happened regardless of when they happen, and not just if they believe it led to the breakdown of the marriage. I will say that because the IFOs require an underlying criminal offense, the language here could be strengthened to include a history of physical, emotional, or financial abuse by one spouse against the other. But we would not want to change in this bill to slow down passage of the bill. We do support that provision as well. And then I want to talk about the use of the home during the pendency of the divorce. We know that domestic violence is a leading cause of homelessness. We also know there's a current practice in DC where a judge can order the parties to continue to live together or allow them to continue to live together. In domestic violence situations, that's really just not possible, right? It's not safe. The person who is using control, who's using violence, is the one who's really making the decisions about whether or not it's safe and whether or not that person, and sometimes the children, can continue to truthfully live there. I also want to add on a slightly more personal, professional note that prior to joining the coalition here in DC, I litigated family law cases in Ohio for over 10 years. Ohio has had a provision that allows for the exclusive use of a home to be awarded during this temporary orders or pendente lite phase for much longer than the over 10 years that I practice. And courts routinely considered these requests for relief, thinking about the asset and maintaining the asset, as well as the resources of the parties, best interests of the children, lots of factors that they would consider that weren't necessarily in the code. But I want to tell you that the sky didn't fall. It works. And judges considered all the things that they do ultimately at the end of a divorce, but helped parties really maintain a safe living situation as they went through the difficult process of separating their families. So we ask council to consider that one suggestion that we have for the bill that might strengthen that one piece, but we do fully support the bill as it's written and look forward to continuing to work with our colleagues and survivors who will be testifying today and with council to help make this process easier for survivors. Thank you for the opportunity to testify, and I'm happy to answer questions.
Thank you so much, Michaela Deming. We will next turn to Elizabeth Selmo from Feldesman Tucker Leifer Fidel LLP.
Thank you. Hello, good afternoon. My name is Elizabeth Selmo. I'm a partner in the Domestic Relations Practice Group at the law firm of Feldesman Tucker Leifer Fidel, which is in its 53rd year of family law practice in the district. I myself have been practicing in the district for 8 years and 14 years total, all of which I've been practicing family law, and I'm currently co-chair of the DC Bar's Family Law Community Steering Committee. My work with domestic violence survivors is what drew me to the practice of family law. And I support the objectives of Bill 25-42 and some of its proposed language, but overall my colleagues at the firm and I must oppose the bill as drafted because we're concerned that the imprecise language of the bill may cause more problems than it solves, including in some instances for the DV survivors it seeks to protect. First, we do support the bill's proposed change to remove the waiting periods as to divorce and separation. We do have some concern that this might result in some folks filing prematurely without first attempting to settle matters out of court. But we do believe that removing the waiting period will eliminate a frequent barrier for DV survivors in leaving abusive marriages and increase access to justice for district residents generally. As to the bill's introduction of evidence of domestic violence as a specific factor in the court's analysis of equitable distribution and alimony, our primary concern is that this undermines the no-fault regime of divorce that has long been the standard in the district. For example, previously adultery was its own factor, but it was removed with prior revisions to the code, in part because when underscored in that way, it was often given greater significance than is contemplated by what should be the overarching analysis of what is equitable, just, and reasonable after considering all of the factors. This is in no way to say that family court judges should not be considering evidence of domestic violence. They absolutely should, and in our experience, they do. But rather, it's unnecessary as a standalone factor in either the alimony or equitable distribution statutes. That said, if the council concludes that a reference to domestic violence is necessary to protect survivors, we suggest including it at the end of what is already the previously referenced circumstances that contributed to the estrangement of the parties. That factor in itself is not time limited. So I understand that there could be some concerns, about pro se litigants not understanding that they can tell the whole fabric of the relationship. But again, our experience is that the court is routinely taking that information into consideration. And there is some concern also that calling it out as a factor could lead to it being somewhat weaponized by abusers who think that they can somehow negate some information that the survivor might have by also presenting, questionable information about domestic violence in the relationship. So similarly, we would suggest making that addition also to the alimony statute, which contains the same factor. Lastly, the most significant concern I have is with the proposed language regarding exclusive use and possession. And that's because that language is lacking in critical details. First and foremost, the phrase "without regard to the respective interests of the parties in the property" should not be included. Rather, title and distinct ownership interests in a property should specifically be considered as one component in determining what a fair and appropriate outcome under the circumstances would be. The mere fact that title may not be dispositive does not mean it should not be considered. In fact, preventing judges from considering title in such an analysis opens the doors for significant violations of property rights, particularly in situations like we're currently experiencing, where pendente lite orders are sometimes in effect for a year or more, which will only complicate the ultimate resolution of these issues at trial. Looking at the pendente lite use and possession statute of our neighboring jurisdiction, Maryland, is very helpful. There, over the span of 5 code sections, there is detailed language that informs the court's analysis for use and possession, which is actually only available in child custody matters. So that's something further to consider when looking at the language here, but either way, it does include specific factors to determine as to whether to issue an order for use and possession, and also handles payment of expenses such as mortgage and maintenance, and sets time limits on the duration of those orders. Those kinds of details are critical to avoiding injustices and unnecessary complications when it comes time for decisions after the benefit of a full merits trial. In closing, precision is necessary both to ensure that the intended results of the proposed legislation are achieved and that additional problems or unnecessary complications are avoided, because such complications only result in greater burdens on the litigants and the courts. I encourage the council to seek additional input from family law practitioners, DV survivor advocates, and judicial officers when in the conferencing phase on this bill. We do think that the objectives are admirable, and if I or anyone at the firm can be of assistance, we will gladly make ourselves available. Thank you.
Thank you very much, Ms. Selma. Next, we will hear from Aida Vindel from DC Volunteer Lawyers Project. I'm going to remind folks, public witnesses have 3 minutes, folks and organizations have 5 minutes. If you can also watch the clock and try to keep your testimony within that time. Please go ahead.
Thank you. Good afternoon. My name is Aida Vindel, and I am the co-legal director of DC Volunteer Lawyers Project. I am here today to provide testimony in support of the Grounds for Divorce, Legal Separation, and Annulment Amendment Act of 2023. The bill ensures that survivors of domestic violence, particularly those without attorneys, are provided a fair and just opportunity to separate themselves from their abusers. The bill proposes 3 important changes that will make the law more friendly to pro se litigants, who constitute the vast majority of parties in these cases. Today, I will speak about 2 of those changes. The first allows judges to award exclusive use of family homes during the initial phase of a divorce. On average, a divorce matter can take anywhere from a year to 2 years to resolve, making this amendment vital for survivors to be able to stay in their homes while the divorce is pending. In a divorce case, a party can ask a judge for a pendente lite or PL hearing so that the judge can make an initial temporary determination on some important items, giving both parties some clarity and stability while the case is ongoing. Once this case is over, either because the parties reached an agreement or have gone to trial, there will be a permanent resolution. In our experience, judges set PL hearings 1 to 3 months out from the date of request. Judges order parties to exchange evidence through discovery deadlines. At PL hearings, judges hear testimony and review that evidence to issue temporary orders on matters that are so important that waiting until the trial in that case would cause undue hardship. These safeguards are often the only way that a survivor has access to financial and proprietary documents that are often held solely by their abusers. As the code is currently written, judges already have the authority to issue temporary orders to decide important issues concerning child custody, child support, alimony, attorney's fees, and dissipation of marital property. It only makes sense to amend the code to authorize judges to consider and decide on a party's request for exclusive use of the marital home. Even with this amendment, judges will still have the discretion to decide whether it is appropriate to award temporary possession of the home or not, based on specific circumstances of that case. But by adding this language, we are making survivors aware that they do not necessarily have to choose between staying in the marital home with their abusers or leaving the home entirely during the divorce proceedings. I should note that judges in civil protection order cases also have the authority to award temporary use and possession of a marital home. But in DCVLP's experience, a CPO hearing is not always the ideal forum to address these issues, nor is it always the safest option for survivors. CPO trials are scheduled just 2 weeks from the date of filing, and the typical CPO trial lasts only about a few hours. Many survivors in CPO cases are also unrepresented and unfamiliar with the laws that allow them to make these kinds of requests. Furthermore, CPO judges are often pressed for time and focused on more immediate safety issues. Their priority is ensuring that the petitioner is safe and turning to that next case. Use and possession of a home is unlikely to be the focus of that proceeding, and discovery on such matters is rare. Relatedly, judges are often reluctant in CPO cases to address ancillary issues, particularly if there is a related divorce matter. There are important safety considerations at stake here. As the committee knows, DC has a shortage of affordable DC housing, and space at domestic violence shelters are scarce, with potentially devastating implications for victims of DV who are forced to choose between remaining in an unsafe home with their abuser or housing insecurity. Economic abuse is a common theme in domestic violence cases as well. DCVLP often hears stories from survivors who stayed in abusive marriages for years because they were told by their abuser that a judge would grant them custody of the children because the home is under the abuser's name. Time and again, we've seen perpetrators of domestic violence abuse the litigation process to further harass our clients. We've seen abusers make up reasons to delay the final resolution of a divorce. By example, a current client of ours was forced to wait 1 year because the abuser withheld consent. At the party's first hearing, the abuser, over our client's objection, insisted that they had property to divide, namely a TV, jointly purchased during the marriage. Because of this delay tactic, the parties were sent to mediation, prolonging the case for an additional many months. This leads me to my second point. By eliminating the required waiting period for spouses seeking divorce, this bill empowers survivors the chance to move in a timely manner and focus on rebuilding their lives rather than remaining in a state of limbo for months. I would like to thank the Council for considering the Grounds for Divorce, Legal Separation, and Annulment Amendment Act. This bill will lead the district closer to protecting the rights of survivors of domestic violence and their children. Thank you.
Thank you so much, Ida. Next and last on this panel, we will hear from Melissa Millar from SEDEC DC.
Good afternoon, Councilmember Pindo and members and staff of the Committee on the Judiciary and Public Safety. Thank you for the opportunity to testify today on Bill 25-42, the Grounds for Divorce, Legal Separation, and Annulment Amendment Act of 2023. I'm Melissa Millar, Policy Director for SEDEC DC. Headquartered at UDC, SEDEC DC's mission is to safeguard the legal rights and financial health of DC residents with low incomes dealing with the often devastating consequences of abusive debt collection practices and other consumer-related issues. Bill 25-42 would eliminate the mandatory waiting period parties are currently required to show before a divorce is granted in the district, allow a family court judge to factor in evidence of intrafamily offenses, and allow a family court judge to award exclusive use of the family home or dwelling while litigation is pending. We support the bill in its current form and desire to see action on this legislation as it incorporates intrafamily offenses as a relevant factor the court may consider, providing recognition for survivors of domestic abuse. However, we offer the following comments and suggestions for the council to consider. Removing the waiting period would be beneficial to survivors of domestic violence and economic abuse. Economic or financial abuse refers to efforts by an abuser to create financial dependence on the abuser. For example, a Zedek DC client who in her youth was sex trafficked and then entered unwillingly into a decades-long marriage with her abuser. The abuser refused to let her finish high school, instead forcing her to have children, greatly limiting her ability to establish financial independence. He also forced her to use her credit to purchase a house for them and to put all of the household utilities in her name. After many years of suffering, the client finally escaped and filed for divorce, but instead of getting the immediate relief she desperately hoped for, a divorce from her abuser and possession of the home in her name and in which she planned to continue raising their children, she was forced to wait a year for the divorce. Because the client fled the family home and stayed with family to escape her abuser, he laid claim to the family home and refused to move out. While the statutory waiting period dragged on, the client fought an uphill custody battle in which her lack of stable housing put her at a great disadvantage. The abuser also stopped paying the mortgage and the utilities for the family home, damaging the client's credit score and making it increasingly difficult for her to find alternative housing large enough to accommodate herself and her children. During the divorce proceedings, the court did not force the husband to make the necessary home payments and did not award the client exclusive use of the home, despite the fact that she could not safely cohabitate with the abuser. Ultimately, the home was sold as part of the divorce. Had there not been a year-long waiting period for this client to file for divorce, her and her children's lives would not have been so significantly destabilized by her sudden lack of stable housing, and her husband would not have had the opportunity to damage her credit. For many survivors of domestic violence, economic abuse follows. According to the Bureau of Justice Statistics, 85% of all victims of domestic violence are women. And according to the National Coalition Against Domestic Violence, between 94 and 99% of all survivors of domestic violence experience economic abuse. Economic abuse involves maintaining control over financial resources, withholding access to money, or attempting to prevent a victim or survivor from working and or attending school in an effort to create financial dependence as a means of control, which can often result in the economically abused partner's poor credit. Many clients find themselves in this position when escaping an abusive relationship. And in addition to poor credit, economic abuse has been found to negatively impact quality of life, increase outstanding debt, increase depression, anxiety, and suicidal ideation while lowering self-esteem, and increase the likelihood of food insecurity and mortality. The DC Council should here or in a future bill create legal protections for non-consensual credit-related transactions that occur in a relationship where one person uses coercive control to dominate the other. Recognizing this reality for so many survivors may further underpin the case for why waiting periods for divorce are harmful. Economic abuse has long-lasting effects on survivors. While DC law does not currently contain a definition of economic abuse, growing national recognition of the gravity of its impacts led to federal codification of the term through the Violence Against Women Act Reauthorization Act of 2022, effective from October 1 of last year. And Maine, Texas, and California recently enacted laws that provide a variety of civil, criminal, and non-judicial remedies for survivors of economic abuse. The VAWA definition for economic abuse in the context of domestic violence, dating violence, and abuse in later life means behavior that is coercive, deceptive, or unreasonably controls or restrains a person's ability to acquire, use, or maintain economic resources to which they are entitled, including coercion, fraud, or manipulation, to restrict a person's access to money, access, or credit, or financial information, unfairly use a person's personal economic resources, or exerting undue influence over a person's financial or economic behavior. As state and federal actions have both shown, protections against economic abuse are necessary, and we urge the Council to work with domestic violence survivors and advocates on how best to incorporate protections against economic abuse into DC law. And we would be happy to work with the committee and others on a working group to analyze various jurisdictional approaches to DC law to develop recommendations on how best to incorporate protections. And thank you for the opportunity.
Thank you very much, Melissa Millar. Appreciate it. I do want to recognize we've been joined by my Ward 6 colleague and member of the committee, Councilmember Charles Allen. Councilmember Allen, welcome. And I can turn to you and give you some extended time if you'd like to make an opening statement and if you have any questions for this panel.
Thanks. I did just have kind of an opening statement. I didn't have any questions, but I did want to make a statement, and I'm happy to follow your flow if you'd let me to go now or later.
Sure, please go ahead.
Okay. Well, Councilor Pinto, I wanted to thank you for moving both these bills forward quickly to a hearing today. I support them both, and I'm going to speak more on Bill 25-42. Certainly support the committee moving forward quickly with 25-44 as well. The introduction happened before we had a chance to join as a co-introducer, so I just want to make sure it's clear I am on board. And I want to thank Councilor Nadeau for working with Legal Aid, Kids in Need of Defense, and others to introduce it. On Bill 25-42, it modernizes our law around divorce, separation, and alimony. I'm likely not gonna be able to stay for the questions for the rest of the hearing. I've got to get to another hearing, but I did want to make sure I showed up and spoke to this. Our divorce and separation statute, it's paternalizing, it's sexist, and it's dangerous. The state has no interest, zero, in failing to recognize married people as the adults they are. Marriage is a legal contract. It is not a cage. It's also a legal contract that can have life or death consequences. It is simply antiquated and unjust to force either party to remain in a marriage they don't want to be in for even one day more than they want to stay married. The ridiculous waiting period, either 6 months if the divorce is uncontested or a year if it's contested, what it does is it puts us, the government, into the home when we don't need to be there. And it's the perfect recipe for emotional, financial, and physical abuse. It boggles my mind that our laws are going to trap victims of domestic violence for 6 months at the very least in dangerous relationships if their abuser objects, and for a year. If they have children, this means kids becoming a bargaining chip that further traps the abused spouse in the marriage or forces them to make other concessions to protect themselves and their children. And what do we care if you're still cohabitating or in a sexual relationship with one another? It's none of our business why you choose to marry or why you choose to divorce or what either looks like for the two of you. So in short, I think we want to move this bill forward quickly. I'd also recommend that it explicitly state that it applies to all marriage contracts currently in force. This is just a vestige of the District of Columbia that we don't want to be anymore. It's basically the government saying women don't have the mental capacity to enter into contracts. And if they do, that they better mind their husbands, or we're just going to make it really hard for them to leave. And make it even harder if their husband wants them to stay. Of course, this statute applies to same-sex couples too, but the origins of it are when women were legal property and had no will of their own. I think this is simple. Current law is at best nonsensical, it's insulting, and at worst, it actively facilitates abuse. So thank you, Councilor Pinto. I want to thank our witnesses for coming forward today. I know I can't stay with you for the rest of the hearing. We just wrapped up a hearing of my own. I need to make it to another one now. But I just wanted to make sure that I spent the time to be here, to be on record in support of this, and in sharing my hope that the committee is able to move forward with urgency. So thank you, Councilor Pinto, and thank you to all the witnesses today.
Thank you so much, Councilmember Allen, for being here and your strong support and statement. I think that was very well articulated. So I have a couple of questions for these witnesses, and I want to start with Julia Ward and your experience in representing some of these cases. If you can speak to what some of the practical consequences you've seen of these waiting periods, and if you have a sense of if other jurisdictions have moved forward in eliminating these waiting periods from their laws.
Yes, absolutely. Thank you, Councilmember. In Legal Aid's experience representing specifically survivors of domestic violence, but also just litigants generally in the domestic relations branch, we have definitely seen a lot of issues with the current waiting periods. Like I talked about, we definitely see a lot of confusion amongst litigants. Over 83% of litigants in the domestic relations branch are unrepresented, and they are struggling to understand the process as it's currently written. We know that that also just leads to a lot of court congestion and cases being continued, cases being filed when they're not ripe. We also specifically see, especially when we're representing domestic violence survivors, that the current separation waiting periods are weaponized against them. The courts, enforcement of the statute as it is written right now becomes part of the control and coercion cycle that domestic violence survivors are subject to by abusive spouses. And so we have had several cases where, there was no reason for the case to carry on longer, except for the fact that the abusive spouse was withholding their consent. So we do believe that this would be a hugely significant step for domestic violence survivors to be able to leave an abusive relationship if they were not beholden to these very antiquated and paternalistic separation waiting periods. To your question about, the trends across the country, we do know that there is a significant national trend towards, reducing and eliminating the separation waiting periods. Our office did a 50-state survey. We can say that over 20, I think it's about 23 states currently have no separation waiting periods. We know that recently, and Councilmember may be aware that Maryland recently included an option to eliminate separation waiting periods for their divorce laws. So this is certainly a step forward that the country is taking, and we would love the district to be able to take that step as well so that district residents can benefit.
Thank you. Thank you so much. Michaela, when you talked about some of the possible improvements of the bill, I just wanted to give you another chance to articulate kind of how that would look and why that's so important.
Thank you for the question. So the suggestion that I had, and this was in conjunction with some members of the private bar who were interested in this language, the way the bill is currently written, it refers to an interfamily offense. We know that interfamily offenses are linked directly with a criminal offense, right? That's part of the definition of an interfamily offense. It's a separate criminal action. But what we understand as domestic violence in the community is much broader than that. We understand that domestic violence includes physical abuse, which is criminal, right? But it also includes emotional abuse. It includes financial abuse, which you heard about from my colleague Melissa as well. And so the idea is to, if possible, without delaying the bill, would be to expand that language to say that the judge could consider the history of physical, emotional, or financial abuse. And, open to suggestions about any more specific than that, of course, but that would more fully encompass what we in the domestic violence serving community understand as all of the pieces of domestic violence that aren't necessarily reflected in our current criminal code.
Great. Okay. Thank you so much. I think that's really an important point. And Melissa Millar, thank you so much for making the point so clearly that we need to be conscientious and responsive to economic abuse as well. Just wondering if you can expound on that and if you think that this bill is the appropriate vehicle for some other changes, or if that should be structured through a separate piece of legislation.
So, answer your second question first. We support the bill as it's drafted, but we wanted to introduce the concept of economic abuse because it fits in with the other considerations of the bill, the waiting period, the interfamily offense, and noting that there are federal protections and there are other states that are looking to protect economic abuse. We do think the district should think about updating the code to include protections for economic abuse, whether it is this bill that is the mechanism that does it, or there's a separate standalone piece of legislation that does it. I think that's really up to the committee to consider. We don't want to stand up this bill moving forward. So if there are potential concerns about expanding the consideration of this bill, we don't want this issue to cause that problem. But we do think the issue is important enough that the council should be considering it, whether here or in the future.
Got it. Fair enough. And I hear you, and this is important to move forward expeditiously, regardless. So I hear you there. Thank you very much. And thank you to all of our witnesses on this panel for your testimony and your really important work in this space. I'm hopeful that we can move forward on this needed reform quickly and get people the support that they need and not be a blockade when people are trying to get out of situations for whatever reason that may be. And as Councilmember Allen put very well, it's not our business. So appreciate all of that. We're going to move on to the next panel of public witnesses on this bill. where we'll hear from Kristen Henriksen from DC chapter, Contessa Allen Starks, public witness, Cynthia, public witness, DC Survivor Advisory Board, and public witness A. Kristen Henriksen, whenever you're ready, please go ahead.
Gotcha. Thank you. Thank you for letting me talk with you today. I am Kristen Henriksen. I am a family law attorney. I've been practicing in the District of Columbia for 20 years, more than 20. I am also here today on behalf of the DC chapter of the American Academy of Matrimonial Lawyers. The fellows in our chapter come from all of the leading family law firms in the District of Columbia. And I'm here today primarily to speak on I call them the non-headlining aspects of the bill. So the bill is titled and focuses on the removal of the grounds for separation. And we support the removal of those grounds, making it easier to file for divorce in the District of Columbia. I want to talk to the addition of the language about evidence of intrafamily offense as a factor in the alimony and property distribution statutes. So as another witness has testified, as many have testified, it is our experience that the court already routinely and consistently considers evidence of an intrafamily offense as it should. Adding that language explicitly is effectively a codification of the current practice. The question we pose to the council and we ask the council to think about is where it should be added. Specifically, should it be its own factor or should it be added to a factor that already exists? So there is already a factor that requires the court to consider the reasons for the estrangement of the relationship between the parties. And we submit that it better fits there. So for example, it could say reasons for the estrangement of the parties, specifically including evidence of an intrafamily offense. As drafted, the proposal is to make it its own factor. And there's two things we believe that raises. One, evidence of an intrafamily offense is one kind of fault that leads to the breakdown of the marriage. It is particularly pernicious, but there are lots of behaviors during a marriage that are particularly pernicious. And we want the council to be careful about what could be perceived as kind of a ranking of marital fault, particularly when, as a whole, our statute over the decades has moved away from a fault construct. And also particularly considering that there is a movement. There are interest groups who are looking to reintroduce fault into divorce statutes. And once we start reintroducing it in one place, we worry that we risk shifting what is essentially backwards into a world where divorce statutes used to focus far less on equity and far more on fault. So again, it should be in there, but the question is where and how do we make sure that we don't send any signal that it might have a greater weight than other factors. This is particularly considering the history of the bill, right? There can also be, someone mentioned that this started with Elaine's law several years ago. There's also some risk that the more we start calling out the fault grounds, the more the court starts thinking about alimony as a compensatory structure or a punitive structure, and in our statute is actually an equitable statute. So I also want to talk about the addition of the use and possession authority to the court. So unlike evidence of an intrafamily offense, this is not a current practice in the court, right? So this would be a big change in the statute, which I just think means we need to take a little more time to think about it. And when we're talking about awarding someone use and possession, we have to remember that also means we're putting someone out of the house, right? It is not just an affirmative award, it is a removal, right? So if we take the removal of the separation requirement, again, which we support, and then we also add the authority to, at the very first hearing in the court, to order that one party can stay and one party has to go, we are effectively now, through the divorce statute, evicting people from their home. So we need to just pause and think about what should that look like. And here is where, so we think there's a question about whether the court needs the authority. We understand the concern of the domestic violence survivor and support it, but we also have to remember that there are so many different kinds of cases before the courts. And if it's going to stay in the statute, we think this part needs a very significant rewrite to include all of the factors that the court should consider. For all of the other areas where the court has pendente lite authority, there is a standard and there is a long list of factors. And that list matches the authority the court has on the divorce. Here we have a disconnect. As drafted, the pendente lite authority is different than the authority at the divorce. So we need to look at those factors, and we are going to be sending written testimony and giving you lots, right? But in particular, those property interests will matter. Thank you.
Thank you so much, Ms. Henderson. I'll come back to you for questions as well. Thank you. Next, we will hear from Contessa Allen Starks, public witness.
Good afternoon.
Hi, good afternoon.
Thank you. My name is Contessa Allen Starks. I currently reside in Ward 7 under Councilmember Vincent Gray. The changes are being asked because it is a very difficult time when trying to separate from an abusive relationship, especially one where physical abuse is present, and even worse, a household of children and safety are concerns. Separation starts long before a person actually calls it quits. People take on a lot of mental, emotional, and verbal abuse, and sometimes more than often physical abuse. That in itself is a very long and tedious process. Then one day you've had enough. You've had the courage to say no more and want to walk away, but the other party doesn't agree. Now you have to argue it out, fight it out, have someone arrested, file a TPO, press charges, find out the address and where the other party can get served, go to the courts and beg for protection, and start a legal separation case. And that's before you can start an actual divorce case, all of which I have personally experienced recently. It doesn't make sense. Now, all of this while trying to sustain your household, explain to your small children however you want to explain it. Try to make sure that the teenage children are mentally okay from all that they have witnessed. If there was threats and physical abuse, you're also trying to stay safe. Unfortunately, for some people, they just rather stay and continue to put up with the abuse other than going through all of the motions to try to get away. Sometimes they don't even survive long after. But when a person does make that first step, they have a lengthy, tiresome, overwhelming process to become unimprisoned by the life that they once knew and thought of as normal. I thank you for your time and your consideration of my testimony, and please pass this bill into law.
Thank you very much, Contessa. Next, we'll hear from Cynthia Smith, DC Survivor Advisory Board.
Good afternoon, council members, survivors of domestic violence, and advocates. My name is Cynthia Smith, mother of 3 daughters. I am in support of B25-42. In the past, I spoke about my personal experience in family court, not in DC court. I would like to share my lived-in experience and suggest what court and policymakers do to prevent the destruction of people's lives once the bill passes, and for the courts to adopt a decision following lawmakers' change in family law. The language in this bill must include why a motion is denied based on DC code, with members of a committee overseeing judicial decision to prevent and reduce harm to families. 90% of the decision made in my case were all judges' discretion, not based on law or state code. I'm in total agreement in no waiting period on filing for divorce. In the state where my case was decided, it had 6 months of separation prior to filing for divorce. Abuse of process went unnoticed, and my abusive husband and lawyer made up story we had been separated for 6 months to expedite the divorce proceedings. I was awarded $1,000 a month for spousal support, but lack of enforcement and accountability harmed my case. In the interest of this DC public policy and the inherent responsibility of spouses to provide support post-divorce and can support until they can support themselves, it must be enforced. Lack of enforcement and accountability put me at risk of being homeless and passing the financial burden on taxpayers. I was receiving public benefits and have not recovered since because of roadblocks in finding justice. Marital asset must be protected and divided equally. Prolonged division of marital asset could lead to further harm to survivors. My abusive husband took care of finances. He cashed out all the bank accounts while in abusive litigation. All too often, even survivors have left in the persons causing them harm. Abusive former partners use legal system to maintain power and control over survivors, physically unsafe and economically and emotionally drained. Adding coercive control and technological abuse to our civil protection law will recognize less visible but no less than dangerous form of abuse and give survivors a chance to seek protection before harm escalates. Using economic abuse to restrict access to someone's finances is a coercive control tactic. I made recommendation on how we can solve the growing problem in family court, addressing false allegation. Nobody does a smear campaign better than some family court lawyers and some of their therapy vendors and angry exes. And the favorites.
Cynthia, you're a bit over time, so I'm going to ask you to summarize and wrap up.
Okay, so everyone has a role in curbing domestic violence. While there's no significant differences in the role that colleagues, healthcare professionals, and friends can play, the secret nature of domestic violence requires vigilance from everyone. Putting an end to domestic violence has a broad implication regardless of who helps identify the problem. And let me just end this by saying I thank you for giving me the opportunity to testify, and I welcome any question. I want to leave you with quotes from U.S. Representative Ayanna Pressley and one of the reps I forgot. Public policy is personal. Fight is personal. Policy determines who lives, who dies, who thrives, and who survives. Our voices matters. People closest to the pain should be closest to the power and to the policy making. Thank you so much.
Thank you so much, Cynthia. Appreciate it. Next and last on this panel, we're going to hear from Public Witness A.
Thank you for giving me this opportunity. I'm a domestic violence survivor and a member of the DC Coalition Against Domestic Violence Survivor Advisory Board. I want equal support for an emotionally abused survivor to a physically abused survivor. Soon after dating him decades ago, he started to abuse me. Almost every day, I was kicked, hit, and punched. I tried to leave him countless times, all ended up with far more severe abuse. At that time, social support and correct information were not available to me, and it was far safer for me to stay with him. I started to battle his abuse by myself. I did everything to mitigate his physical abuse. I appeased and pleased him. I thought his abuse was ending. I got married and lived a normal life from the outside. The reality was his abuse shifted from kicking and punching to other types. He prevented me from leaving the room when he became abusive, forced me to bear his shouting and blaming me, and made me acquiesce to his right to be abusive. It usually lasted for 4 to 5 hours every time. He isolated me from friends and family and prohibited me from working. I was unaware of the cost I was paying. I compensated for my physical safety by ruining my mental health. I developed complex post-traumatic stress disorder. While leaving him this time was extremely difficult, leaving did not end the struggles. He traced me and showed up where I stayed. He threatened me with committing a hunger strike. He sent me more than 100 emails in the first 3 weeks and another 100 plus emails in 3 days when I mentioned divorce. I decided to entrust my divorce with an attorney. I called local organizations over 100 times to seek legal assistance. What I figured out was their lawyers cannot represent me. A judge is highly likely to question the need for a protection order, and the chance of spousal support is slim. It is because I had not had direct physical violence in the previous few years. I believe an emotionally abused survivor needs equal support to a physically abused survivor, especially for getting divorced. Thank you.
Thank you so much for your really powerful testimony. I want to thank all of our survivors for your bravery in coming forward and taking an awful, life-changing situation that you've experienced and turning it into advocacy to protect others from having to go through similar things in the future. Really, really appreciate it. And think it's really good point too about emotional abuse. And again, going back to this, we can't legislate for every exception, but we need to get out of the way in some of these regards and make sure that people can come forward and move forward with separation or divorce when they see fit, and what's best for themselves for whatever reason that may be. I do want to ask you, Kristen Henriksen, about some of what you were talking about of the exceptions. And I think this is an important point in this topic, but we talk about this a lot with the committee on times that we want to empower our judges with discretion to be able to move forward in a way versus requiring the judges interpret the statute as sole tenancy. And so when you talk about some of those concerns about factors, I'm just hoping you can articulate a little bit more of how you envision that functioning in the most appropriate way.
Sure. So if the council is going to add this authority to the kind of list of things the court can do.
And Kristen, I'm sorry, your sound is a little bit muted or muffled. I'm not sure if it's me or if there's something covering.
Is this better?
A little bit. It sounds like you're very far away. But your testimony came through clear.
That is. I have no idea why. I literally have that moved.
Okay, if you can maybe just try to speak
up
loud. Okay.
Right. So if the court is going to add this to the list of things if the council is going to add this to the list of things that the council can do, it should be discretionary, as is all of the other authority that the court has on a pendente lite basis. Our concern is that we need to guide that discretion, right? So on custody, on alimony, on child support, in all of those areas, there is a standard. So for example, in custody, it's the best interest of the child. And there are a list of factors that the court is mandated to consider. And all we're saying is that right now, as written, this statute, we need to examine the standard and we need to add the list of factors. As written, it seems to say that the court cannot consider things like whose house is it? Who is on title? Is it separate property or marital property? And so, again, with every other form of pendente relief, the factors that the court must consider at the PL level are the same factors that the court must consider at the end of the case when they're divorcing the parties. So we think at a minimum, there needs to be some alignment of factors. And there's one particular type of property that is a hard question and requires special consideration. And that is where the home is separate property. And what that means is that one spouse owned it before the marriage or they inherited it during the marriage. And in that circumstance, and it's in their name, right? Mortgage is in their name. A lot of times this is a family home. It's been in the home for generations. And this is true for both low income, middle income, and high income families, right? And in those circumstances, at the divorce, the court has to award that property to the person who owns it, right? They don't get to change title. They don't get to give anyone use and possession. And so as written, this statute would allow the court to let the non-titled spouse live in that separate property for the duration of the case. And then once you let them live in there, that actually gives rise to a claim. It could give rise to a claim for an equitable lien, right? So the divorce proceeding then becomes a mechanism by which to develop and claim a property right that did not exist previously. So that, there's a lot of factors that have to be considered. And then there's that particular category of property that I think we have to ask, do we want the court to be able to give use and possession in that circumstance? How do we reconcile that with what our law says about separate property and what the court can do at the end of the case? And, as with most hard questions, there is an answer or a series of answers that we could live with or a balancing. And we're asking that we come together and figure out what that balancing should be.
Okay. Thank you very much. I
Did
appreciate
you hear it
that.
okay?
Yes.
Okay.
Thank you all. Thank you to all of the witnesses on this really important bill. I appreciate your perspective and look forward to keep working with you all throughout this process. We are now going to turn to our next bill. Bill 25-44. Sorry. All right, we are now going to turn to our next bill, Bill 25-44, the Vulnerable Youth Guardianship Protection Amendment Act of 2023. We're similarly going to have two panels of public witnesses. So I'll call the first panel. We'll hear from June Lee, Director, Immigrants' Rights Legal Services Project. Jessalyn Schwartz, Kids in Need of Defense, KIND. Abel Amin, Public Witness. Marianne Trumbore, Public Witness. And Robin Swanson, DC Volunteer Lawyers Project. All right, so we will go ahead, please, with June Lee, Director of Immigrants' Rights Legal Services Project.
Good afternoon, council members. Thank you for holding this hearing. My name is June Lee. I'm the Director of the Immigration Project at Legal Aid DC. I'm here to testify in support of the Vulnerable Youth Guardianship Protection Amendment Act of 2023. This bill would fix a misalignment of federal law and DC law that currently prevents vulnerable immigrant youth in the district from accessing critical federal immigration relief. Specifically, the bill would let DC Superior Court appoint guardians for non-citizen youth aged 18 up to 21, which would allow them to seek immigration relief known as Special Immigrant Juvenile Status, or SIJ for short. If enacted, this bill would provide life-changing benefits for many immigrant youth in the district. By assigning a court-appointed guardian to care for these youth who have often endured abuse, the bill would protect them against further harm and give them a guardian support in accessing services like school enrollment and health benefits. The bill will also allow these youth to seek SIJ immigration relief, giving them protection from deportation and the ability to live and work lawfully in the U.S. They will also be more likely to be financially self-sufficient due to increased employment opportunities and because they will be on the pathway to becoming eligible for federal public benefits. By way of background, SIJ is a federal immigration law that allows certain undocumented youth to obtain a green card and get on the pathway to U.S. citizenship. Stated in simple terms, SIJ applies to youth who are currently under the care of a person or entity in the U.S. and who would be harmed by deportation because they suffered abuse, neglect, or abandonment by one or both parents. The age cutoff for SIJ eligibility under federal law is 21 years. SIJ cases are unique. Before applying for SIJ immigration relief, the applicant must first obtain a family court order that places them under the care of an individual or entity. This could include a custody or guardianship order. The court must also make additional findings about SIJ eligibility. These findings and orders are called predicate orders, which must then be included in the application for SIDS immigration relief. For example, Legal Aid recently represented a boy from El Salvador who had been physically abused by his father and abandoned by his mother in his home country. He had been afraid to leave his house because gang members were threatening to kill him. However, he came to the US when he was 16 years old and began living with his adult half-sister living in DC. The half-sister became the child's primary caretaker and obtained third-party custody through the family court as part of the child's SIDS case. This is a fairly typical SIDS pattern. The problem is that DC currently does not have jurisdiction to issue custody or guardianship orders to youth who are 18 years or older, unless they're already in CFSA custody or were found to be neglected by the court. So as a result, many youth in DC who turn 18 get precluded from SIDS relief, even though federal law would allow them to apply for SIDS until they turn 21. This is unfair because immigrant youth often face challenges to seeking SIDS relief before turning 18. The Office of Refugee Resettlement reported that in 2022, about 72% of unaccompanied children detained at the border were 15 years of age or older. Also, barriers such as lack of language access, legal knowledge, and financial resources make it hard for these youth to learn about SIDS and find a lawyer. Indeed, within the past year, Legal Aid handled multiple SIDS cases for children who were already 17 years old. For example, last December, Legal Aid met a 17-year-old who had been abandoned and neglected by both of his parents in his home country, and who had arrived in the US by walking on foot for more than 2 weeks in dangerous heat while lacking food and water. By the time he came to Legal Aid and was determined to be eligible for SIDS, there were only 3 weeks left until his 18th birthday. Within that time frame, a Legal Aid attorney gathered facts and documents from the child and his sister, who was seeking third-party custody, obtained translated documents for court filings, filed a complaint for custody and motion for SIDS findings, and represented the child and his sister in an expedited hearing in DC Superior Court. While the attorney in this case was successful in obtaining the predicate order on an expedited basis, most children in this situation would not be so lucky. Many attorneys would not be able to turn this around in 3 weeks, and judges aren't always able to schedule hearings on such short notice. So many people in this situation in DC would just be precluded from SIDS relief. This bill fixes this problem and follows more than a dozen other states, including Maryland and New York, who have already enacted similar laws. As a sanctuary city, DC should follow suit, because you should not need to relocate to Maryland in order to access such critical federal immigration relief. In conclusion, Legal Aid urges the Council to pass this important bill that will enhance safety and opportunity for immigrant youth residing in DC. Thank you.
Thank you very much. We will next turn to Marianne Trumbore, public witness. Oh, all right. We will go to Robin Swanson, DC Volunteer Lawyers Project. And some of this panel is not here yet, so I'm going to go ahead and call our other names for our other panel, and we'll just keep moving forward in order. So we'll first hear from Robin Swanson from DC Volunteer Lawyers Project, and then Danielle Gestal, Capital Area Immigrants' Rights Coalition, Diane Weinroth from American University of Washington, Sandra Benavente from IUTA, and then Maria Gomez, public witness. Go ahead, Marianne.
Thank you. I'm sorry, I was with a student, so I missed the first click for the panel. I appreciate you bringing me in. Good afternoon, Chairperson Pinto and members of the committee. My name is Marianne Trumbore. Since 2015, I have been a licensed social worker at Cardozo Education Campus. I am also a Ward 6 DC resident and homeowner. Working with undocumented students at Cardozo over the last 8 years, I see every single day the work ethic, resilience, courage, and unlimited promise of these special young people. This is why I am asking you today to support this legislation. Current DC law unintentionally disqualifies too many otherwise eligible youth from even attempting to avail themselves of crucial immigration relief that will secure their futures and allow them to contribute more fully to our DC community. In my role at Cardozo, I connect students to a variety of services, including immigration legal services. I repeatedly encounter students who I cannot refer for representation because after they wait for months in shelters upon entering the US, finally settle with sponsors, and enroll in school, They are too close to turning 18 to attempt a special immigrant juvenile status case, often the only path they have forward to documented status in the United States. Over the years, many of my students have had to move to other jurisdictions so they can pursue SIJS. For some families already established in DC, this move is not an option, denying the student a chance at a secure future. For those who do move, they uproot their lives all over again. It is heartbreaking to see these promising young people leave our school after they have made friends and established themselves. Last school year, we lost a straight-A student with many friends to an SIJS-related move to Maryland. For students and staff alike, it was very difficult to say goodbye. We must ensure other students and families aren't forced to make the same choice. These young people are well-positioned to finish their educations and work in DC, filling sorely needed positions in healthcare, education, and government service. We will all benefit by having bilingual high school and college graduates call DC home for years into the future. I am thinking of two students I have now. They have 3.92 and 4.04 GPAs this year, respectively, and their English is excellent. Both came to me asking to be referred to immigration legal help, but remain without attorneys and without any avenue to lawful status because of their ages. When I told one of them about this proposed legislation and the possibility that he could apply for SIJS in the future, his face lit up. He said, "This makes me so happy. These are two students who could no doubt go to college and have successful careers. But first, they need documented status to access federal financial aid and to work legally. At Cardozo, we can do a lot for our students to educate them and help them grow. What we cannot do is secure their futures in the United States. You have the power to do that. You have the power to help them contribute to our community, build their lives, and yes, in some cases, even save their lives. Please pass this simple legislation, bringing DC in line with its neighbors and federal law. Let's show these incredible young people how much we believe in them. I am begging you. Lives and futures depend on your support. Thank you so much for your time and attention today."
Thank you so much, Marianne. I really appreciate it. Next, we are going to turn to Abel Amin, public witness.
Hi, Chairperson Pinto. Thank you for this opportunity to testify. I'm not an expert on this field. I'm only here to offer my testimony as a former asylee myself and an advocate for immigrant justice. This bill is part of 5 bills that 6 if you count the excluded workers, which is not quite a bill, that we've been pushing together because they would be transformative in how they would assist the immigrant community in DC. Thankfully, the others have been successful. This is the last piece of the puzzle for us. I'm wholeheartedly in support of this bill. It is quite a simple thing that could have transformative change for immigrants in the city. Every day that we delay before we pass this bill, someone is turning 18 and losing their opportunity. So I want to encourage you as fast as possible to pass this bill and make this law come into effect. And if necessary, to pass emergency legislation, and if possible, to do that alongside it. I also want to encourage, DC often says it's a sanctuary city, and that is true, that we do not assist in bringing people to danger. But there is so much more we could do and to make DC a more welcoming city for immigrants. And one part of that is legal assistance. Just the other day, I was at a legal clinic set up by volunteers to help people apply for asylum before their 1-year mark. They reach their 1-year mark and their parole expires. And these are volunteers, some attorneys, some non-attorneys, coming together, putting the time to help people apply for asylum. And I was struck by the fact that how much more help is needed. And this council has a responsibility, and I think should put more money towards legal assistance for immigrants that are not only being bused here, but are coming through many other ways. And also to assist youth in applying for this program. We need more legal assistance, immigration legal assistance programs, and we need to find more money and more grants to offer to those that are offering these services. There are some programs, but we need to do a lot more to make this city more welcoming to immigrants. Thank you very much for your time.
Thank you so much, Abel. I really appreciate your testimony. Next, we'll hear from Robin Swanson, DC Volunteer Lawyers Project.
Good afternoon, Chairperson Pinto. My name is Robin Swanson, and I'm a supervising attorney at the DC Volunteer Lawyers Project. Thank you for the opportunity to provide testimony today in support of the Vulnerable Youth Guardianship Protection Act of 2023. DCVLP believes that a life free from violence and abuse is a basic human right. Our mission is to advocate for low-income survivors of domestic violence, at-risk children, and other vulnerable individuals through comprehensive pro bono legal services, to empower victims with knowledge, resources, and ongoing support, and to broaden our impact by engaging, training, and supporting a strong and diverse network of volunteer lawyers and community volunteers. DCVLP's immigration program works with survivors of gender-based violence and at-risk children seeking humanitarian relief through the asylum process, U visas, T visas, under VAWA, and finally through special immigrant juvenile status, also known as SIJ. Last year, we provided full legal representation to over 140 immigrants. We also provided brief legal consultations to approximately 280 immigrants through the free walk-in clinics we operate throughout the city. I'm here today to talk to you about some of the at-risk youth we encounter through our immigration program. As you know, SIJ is a humanitarian immigration benefit that provides a path to legal status for abused, abandoned, or neglected immigrant youth. Under US immigration law, a young person is eligible to seek this status if they are under 21 years old and unmarried, are physically present in the United States, and have obtained findings from a juvenile court determining that they cannot be reunited with their parents due to abuse, abandonment, or neglect. The first step in applying for SIJ is to obtain a prerequisite finding from a juvenile court. Critically, at this time, with certain limited exceptions, DC Superior Court does not have jurisdiction over youth between the ages of 18 and 21. This means that just because a youth lives in DC, someone who is otherwise eligible for this benefit and is between the ages of 18 and 21 cannot access the protection that SIJ was intended to afford them. In our experience, the process for obtaining SIJ is faster and less traumatizing for our young clients than seeking relief through the traditional asylum process. In DC, it generally takes 6 months for applicants to obtain the necessary findings from a juvenile court, then another 1.5 years for USCIS to process their application. Once granted, SIJ provides work authorization, a pathway to seek legal permanent residency and US citizenship, and allows youth to access additional federal benefits and services like healthcare, financial aid, and the ability to terminate deportation proceedings. By contrast, the asylum process can take up to 10 years and involves an intensive interview or court hearing during which applicants are forced to recount their often traumatic history, which can compound their existing trauma. DCVLP regularly encounters immigrants in our clinic who have just aged out of this benefit. Many of the young people we encounter in our clinics were abandoned, abused, or neglected by a parent. Many lack the access, education, and language skills to learn about immigration relief for which they may be eligible. And simply because they live in DC rather than Maryland, they are precluded from seeking SIJ. In one case, we had a potential client come to us 3 days before their 18th birthday, not enough time to seek the necessary findings from the juvenile court. It was heartbreaking to give them the news that they had lost out on this benefit due to their age and the fact that they lived in DC. In another case, a client's twin siblings fled to the US to escape gang violence and to find treatment for a physical disability. Unfortunately, they entered the country just 1 week before their 18th birthday, and there was no time to go through the SIJ process in DC Superior Court. DCVLP urges the Council to pass the Vulnerable Youth Guardianship Protection Act of 2023. Passing the bill will align DC law with the state law of our neighbor Maryland and with existing federal law to increase access to immigration relief through SIJ to vulnerable immigrant youth in our city between the ages of 18 and 21. With access to lawful status through SIDGE, eligible young DC residents will be able to pursue higher education, qualify for certain federal benefits, seek employment in the district, and afford to live in and remain active members of our community. Thank you for the opportunity to present this testimony, and thank you for your ongoing commitment to vulnerable children and the immigrant community here in DC.
Thank you so much, Robin Swanson. We are now going to go back to Jesselyn Schwartz from Kids in Need of Defense, who has rejoined us. Go ahead, Jesselyn.
Thank you so much. Good afternoon, Chairperson Pinto and members of the committee. My name is Jesselyn Schwartz, and I am a senior attorney at Kids in Need of Defense, or KIND, a nonprofit that provides free legal and social services for unaccompanied immigrant and refugee children. We have been serving youth in DC since 2009. I'm here today to support the Vulnerable Youth Guardianship Protection Amendment Act, a bill that would narrowly extend DC's juvenile and domestic relations court jurisdiction to allow a guardian to be appointed for vulnerable aged youth up 18 up to 21. With an appointed guardian and the associated order from the DC court, these youth may be able to seek a federal immigration protection known as special immigrant juvenile status, a critical avenue to legal immigration status for older youth who have been victimized by their parents. Special immigrant juvenile status, commonly referred to as SIDGE, is a pathway to permanent residency and citizenship for young people who have survived parental abuse, abandonment, or neglect. Obtaining lawful status allows those young people to become eligible for federal financial aid, work authorization, and additional benefits that facilitate their full participation in their community. Though federal law allows youth up to age 21 to seek this form of protection, a misalignment within DC law means that here, youth 18 or older are unable to access it. This bill would remedy that. Right now, our office has over 350 open cases, of which at least 290 are seeking SIDGE. This does not account for the many youth over the age of 18 that we must turn away because even though they do qualify under federal law, they have missed the opportunity to apply in DC. Our office turns away at least 2 to 3 youth seeking representation each month because of their age. We know that there are even more young people who never reach out to us, as many community groups and partners of ours know that the youth nearing 18 will not be eligible for our services. Even young people who find a lawyer before they turn 18 face barriers that this law would resolve. One KIND client was preparing to go before the court when their guardian was hospitalized for several weeks with severe COVID-19. While the guardian was hospitalized, this client turned 18 without being able to complete her custody proceedings and lost the opportunity to seek SIDGE. Had the local jurisdiction been extended to 21, we would have been able to seek protection once the client's sponsor recovered from her illness. And this case is not unique. Since January 2022, the DC KIND office has handled more than 25 cases where the client was less than 6 months from their 18th birthday. Last month, a case was referred to our office on a Monday where the client turned 18 on the following Sunday. In 2 days, our office was able to scramble to intake the client, prepare and file the necessary documents, and have a hearing at the end of the week. The assigned judge was in a judicial conference and made time for the hearing on her lunch break. If not for the extraordinary efforts of KIND staff, the court clerks, and the judge, as well as the cooperation of the client and their family, this client would have lost the opportunity to seek SIDGE. Courts, judges, advocates, and the youth themselves. They additionally do not allow adequate time for vital trauma-informed approaches for working with these young people or to build rapport in the attorney-client relationship. This bill could fix these issues immediately. Around the country, more than a dozen states have made changes like this to ensure that all eligible youth can seek SIDGE. KIND has field offices in states like Maryland, Virginia, and Massachusetts, where my colleagues can firmly attest to the positive outcomes for clients of such changes. I urge you to pass this bill to ensure that DC law does not stand in the way of DC youth accessing life-saving federal protections that they are eligible for. Thank you so much for this time.
Thank you very much, Jesselyn. Next, we will hear from Danielle Gestel, Capital Area Immigrants' Rights Coalition.
Good afternoon, Chairperson Pinto and advocates. My name is Daniel Gestel. I'm a managing attorney at the Capital Area Immigrant Rights Coalition, CARE Coalition in Washington, D.C. We are a nonprofit that provides free legal services to unaccompanied immigrant youth who are detained by the Office of Refugee Resettlement. And we also provide services to youth who are released from ORR custody to the district and surrounding counties in Maryland and Virginia. CARE in total has been representing immigrant youth in DC for over a decade, and I am here today in support of the Vulnerable Youth Guardianship Protection Amendment Act. As has been discussed by other people giving testimony today, this is a bill that would grant the Superior Court jurisdiction to appoint guardians for vulnerable youth between the ages of 18 and 21, opening the door for these youth to seek the findings necessary to allow them to apply for special immigrant juvenile status, which is a pathway to legal permanent residence for young people who have been abused, abandoned, and or neglected by their parents. In addition to being protection from deportation, obtaining lawful status allows these young people to be eligible for various benefits that allow them to become contributing and engaged members of the community and to further their lives. Though federal law allows youth up to 21 to seek this protection, currently in DC, as has been discussed, young people between 18 and 21 are currently precluded from seeking the findings from the Superior Court necessary to apply for SIJS. Now, I would like to talk about a specific group of vulnerable youth who would benefit greatly from this bill. And these are youth who are unaccompanied immigrant children in the custody of the Office of Refugee Resettlement, which is the federal agency in charge of the care and custody of unaccompanied immigrant children, who have no friends or family in the United States with whom they can reunify. Ordinarily, when a minor enters ORR custody, the case managers for ORR will look for family members or friends throughout the United States with whom the minor can safely reunify and then work to facilitate that reunification. However, for a child who has no one in the United States who can support them, those minors stay in the custody of ORR until they are 18 and age out of ORR custody at 18. We, as their legal team, along with the case managers in ORR, will work to create a post-18 plan to set that minor up for success insofar as possible. But currently in DC, for minors who age out of ORR custody and become residents of the district, because they are 18, they are automatically precluded from seeking SIJS. This bill would leave the door open for these particularly vulnerable youth who are already at a disadvantage to access the protections and benefits intended by Congress through special immigrant juvenile status. Also, in our practice at CARE, we have seen, and I have seen personally, how the change in Maryland law over the past several years has positively affected both the well-being success for immigrant youth living in Maryland. We are confident that a similar change in DC laws would yield the same positive results for immigrant youth in the district. And lastly, and importantly, the bill not only provides a starting pathway for stability and permanency for these youth residing in DC, but it will allow them to build and formalize relationships with trusted adults who will help them as they transition into adulthood. I've personally seen clients in Maryland who have aged out of ORR care and went to live in Maryland, who have been able to build a community, find trusted adults who have been willing to petition for guardianship. And these trusted adults have helped the youths advocate for access to educational opportunities, for support within those educational institutions, apply for jobs, get cell phones, interpret for them in various settings, schedule and attend medical appointments, all things that young people, particularly these vulnerable immigrant youth, need assistance with as they transition to life and adulthood here in the United States. Immigrant youth in DC also need and deserve that same kind of support. And so with that, I fully support this bill. Thank you for allowing me to present this testimony, and have a great day.
Thank you so much for your testimony and the work that you do. Appreciate you sharing that perspective. Next, we will hear from Diane Weinroth from American University of Washington.
Thank you. I appreciate the opportunity to testify today in support of the Vulnerable Youth Guardianship Protection Act. My name is Diane Weinroth. I'm an attorney who's been practicing and teaching family law and child abuse and neglect law in DC for over 40 years. I also represent youth in special immigrant juvenile matters. I co-teach the Gender Justice Clinic at American University Law School, and I'm special counsel at Children's Law Center, but I'm testifying in my individual capacity. I'm not speaking on behalf of these organizations. As you've heard and as you know, DC and federal law are not aligned with regard to federal law that was enacted explicitly for the purpose of protecting vulnerable immigrant youth. Federal law allows abandoned, abused, or neglected immigrant youth under age 21 who are placed by a state family court in the custody of an individual or entity to seek legal status through a humanitarian visa process called Special Immigrant Juvenile Visa, CJIS. This bill ensures that all vulnerable youth between the ages of 18 and 21 can obtain the factual findings from family court that are needed in order for the youth to be able to take the next step of applying to the federal government for CJIS under federal law. The bill creates a narrow definition of vulnerable youth as an unmarried non-citizen who is under 21 years of age and permits the court to appoint a guardian for the youth until age 21 and to make the necessary factual findings of neglect, abuse, or abandonment. The bill does not change anything about existing DC law regarding child abuse or neglect, and it does not involve DC's Child Protective Services Agency, the Child and Family Services Agency, nor does it involve the DC Office of the Attorney General. Without this bill, these vulnerable youth will continue to face the kinds of challenges you've heard, the tremendous loss of their potential, and bear the enormous emotional and psychological cost of having to live in fear and uncertainty, as well as the tremendous instability in their lives and the risk of harm. This bill ensures that all vulnerable youth who are survivors of abuse, neglect, or abandonment can avail themselves of the protection offered by federal law and then live safe, healthy, and productive lives. Thank you very much.
Thank you so much. Appreciate that. Next, we will hear from Sandra Benavente from IUDA.
Good afternoon, Chairperson Pinto and members of the committee. My name is Sandra Benavente, and I am presenting this testimony on behalf of IUDA today. IUDA's mission is to advocate for low-income immigrants through direct legal, social, and language services in the DC metropolitan region. We envision a community where all immigrants succeed and thrive in the United States. IUDA provides her services to immigrant youth who have been abused, abandoned, or neglected by their parents or caregivers, and who may be eligible for Special Immigrant Juvenile Status, SIJ. In 2002, IUDA's legal team assisted with 161 SIJ petitions for abandoned, abused, or neglected youth across the region. IUDA joins other community organizations that serve this population in voicing strong support for the Vulnerable Youth Guardianship Protection Act, which will allow youth survivors up to age 21 to receive guardianship and eligibility for humanitarian protection. Many of the immigrant youth that IUDA serves arrived in the U.S. without parents or legal guardians as unaccompanied immigrant children after fleeing their home countries due to violent conditions, physical abuse, or neglect. Many minors endure sexual and physical abuse or threats of violence from attempted gang recruitment or by smugglers and other criminals they encounter on their way to the U.S. Some were separated from their parents or loved ones on their journey to the U.S. or subjected to prolonged detention, further compounding their trauma. Without lawful immigration status and with a lack of familiarity with the legal rights and the resources available to them, these youth are uniquely vulnerable to abuse, exploitation, and re-victimization. They also often face the additional obstacles of language and cultural barriers. As a result, they lack the opportunities and resources to live safe, productive lives and to plan for their futures. Currently, undocumented youth survivors aged 18 up to 21 living in the DC area are in an especially vulnerable position and unable to obtain judicial findings required to apply for humanitarian protection. This act will directly address this issue by allowing them to have a court-appointed guardian and subsequently access protection through SIJ. SIJ provides a pathway to seek lawful status, which enables immigrant youth victims of abuse, neglect, and abandonment to live without the fear of deportation, attain employment, access public benefits, and to overcome previous victimization to become healthy and positive adults. AYUDA strongly urges the Council to pass the Vulnerable Youth Guardianship Protection Amendment Act and ensure that this population has equal access to justice, safety, and well-being. Thank you for your time today.
Thank you so much, Sandra Benavente. And next and last on this panel, we will hear from Maria Gomez, public witness.
Good afternoon, Councilmember Pinto. I am here today as a Ward 1 resident, a registered nurse, and a public health executive for the last 4 decades in the District of Columbia. I am also a member of KIND, Keeping Kids Safe Campaign Leadership Council, which advises on children first, pragmatic policy solutions. In my many years in practice, I have established programs where young people were offered the necessary tools to extract the talent that they have in them to succeed in our existing economy. Today, I'm here to strongly support the Vulnerable Youth Guardianship Protection Act and to thank you and the committee for your insight into what this protection will provide immigrant youth 18 to 21 years of age. As a young immigrant landing with a parent and a USA passport in hand about 50 years ago, I had the privilege to be surrounded by a handful of angels, teachers, neighbors, and yes, even strangers that helped us navigate this city efficiently, despite the lack of English language, money, and few social supports. I owe my extremely successful middle-class life and the success of my daughter about to become a surgeon to the many angels that looked up to me and my mother during these uncertain times. We can all agree that for some of us in this country, this were safer times. Yet, my long life commitment to young people has shown me the other side of the coin. Through my work in community health in DC and founder of Mary Center, I have worked with young people who, for a variety of economic, climate, and political unrest, end up abandoned and traumatized for life in this city. These young people quickly become disheartened because without the path of permanent legal status, which this bill would enable by allowing their access to prerequisite superior court proceedings, they are forced into underground markets such as sex and labor trafficking and exploitation just to provide food and shelter. I have witnessed too often our young immigrants not getting immunized, being forced to have unwanted children, dropping out of school, and tortured daily because of their undocumented status, their overall instability and lack of guidance and support. I have seen that when youth are able to achieve the stability that legal immigration status provides, they're able to lead healthier, happier, and more successful lives. In short, this bill would lead to improvements in health outcomes and overall well-being of immigrants, youth in the city. We have the power in this city to change their trajectory. Let us commit to passing this bill for them, for us, and to demonstrate our nation that the children are the strongest future we have. Thank you for the opportunity to testify on this life-saving bill.
Thank you so much, Maria Gomez, and thank you to all of the witnesses on this panel testifying in support of this really important bill. I do have a few follow-up questions, and June Lee, if you're still here, I want to start with you as someone who practices in this area, in this region, if there are inconsistencies right now with how DC handles the law in this regard versus Maryland and Virginia, and if there's a benefit of having some consistency there.
Chairperson Pinto, I actually probably defer to some of my other colleagues on this who have studied the other jurisdictions more. However, I can say that this bill was crafted in a very intentional way to try to minimize any disturbance to existing DC law. It doesn't alter the definition of a child. It doesn't take away any resources or rights from children in foster care. So I do know that this was drafted very carefully and intentionally. In terms of the other sort of differences between state laws, I think I'll defer to some of my other colleagues who are on this panel.
Okay, no problem. Does anybody else have other thoughts on that, on other surrounding jurisdictions and their law in this regard, and if there's a benefit to having consistency here among the states in the region?
I would just say that I don't know that I'm going to answer your question directly, but I think having the consistency is really, really important, as these youth are constantly, because of the expense in housing, constantly in their jobs, going from one jurisdiction, living from one jurisdiction for 6 months and another for another year, and then coming back and forth. And so having that consistent bill that would allow their guardians to actually work with them would be really, really, really important.
Okay, thank you very much. Jocelyn, can you speak to how expanding the age to 21 would specifically help support your clients? And how many more people you think you may be able to serve if this legislation is passed?
Sure. And just to follow up on what Maria was saying, the not being forced to move is one of the biggest things. A lot of our clients do need to move to another jurisdiction in order to access relief. And the benefit versus Virginia is that children in or youth in DC would then be able to receive this benefit after 18 and access that relief, which in Virginia does cut off. They just need to get their filing in at that time in Virginia. So to your specific question to me, it would be a huge difference for our clients, because we do see a lot of children and youth coming in who are on the older end, 17 and 10 months, 17, 11 months. We got another referral yesterday of someone who turns 18 on July 25th. And we have to scramble with the court to see if there's a date. And during the summer, especially, that's a very hard thing to try to sort out as everyone travels and it gets very booked up with the judge and things like that. So we think that this would really open it up to give us another path to make sure that these youth have a supportive adult in their lives who can help them navigate these really complex changes that they're experiencing and coming to this new country, this new place, navigating healthcare and school enrollment and things like that. We do have partnerships with schools where they're trying to refer us the older students, and we just cannot help them because we know that there is not enough time to get the information that we need and get all the pieces in place. Service is often an issue, making sure we can properly serve the parents, as is their right to receive notice of the hearing and of the proceeding. And so if there's any issues with locating them in the home country or getting service to them, that's going to slow down the process, and having this length of time is really helpful. We also can connect to more pro bono volunteers in the community and expand the reach of this type of case and involve more individuals in our community and help more and more clients in doing so, not just what our small team of attorneys in Kind's office, but our large network of pro bonos can do. And we just really want the youth to have stability, and that's really the core of our work, is to stay in the same school, in the same home, in the same neighborhood, and really be providing a lot more to these youth as they come into the DC area and start figuring out all the newness of being here. In terms of a number, that's a hard thing to guess, because we haven't, as I said in my testimony, we haven't been tracking, because if someone is referred to us and they are too close to or over 18, we don't track that we had to turn them away necessarily. And then there are these networks of individuals like Marianne Trumbor at schools that don't refer us clients that they know we're not going to be able to take. We may be able to pass on a different referral list, but it's hard.
Okay, that makes sense. Okay, thank you very much. And speaking of Marianne Trumbor, if you're still here, can you talk specifically about the guardianship component of this bill? And you spoke a little bit about this, but just kind of articulate why this piece is so important.
One of the other panelists touched on it. The guardianship with these kids is very tricky, because, they will have at times multiple extended family members in DC, but they don't really know any of them particularly well. And there's a lot of moving households, and who has, it's just one more unstable aspect of these kids' lives. Sometimes they end up getting kind of passed around. And they've already dealt with so much uncertainty and so much getting uprooted and so much trauma and things in their young lives you can't even imagine. And the family situations are extremely complicated. So just any kind of any structure, stability, and support we can inject is beneficial. Thank you.
Well, thank you so much.
Can I just add a little bit, Councilmember? I think this is great. Thank you, Marianne. I think that the fear of being deported, what I saw often, as I'm sure Marianne you do see every day, is so intense that the kids are fearful to go to the doctor because they just don't want to know like what's wrong with them, because they have to work, because they're afraid of accumulating debt. They're afraid of just, being known by somebody else that they don't have documents. And the family members that sometimes come in their lives, truly, many of them are so overwhelmed already with their own kids, their own families, their own circumstances, that barely, like, being able to give them shelter is about all that they can give them. And in many times, the places where they live, they have limited amount of people that they can have in a household. So who ends up leaving and asked to leave immediately is that child. So the instability of not having a home and not having someone to go to is what forces those kids to go out into the streets and find ways to make a life. And I just want to emphasize that that's very often what happens. It's not a case here and there. It's many of these children.
I hear you. Okay. Well, thank you very much. I want to thank all of our witnesses today who testified on this bill and both of our bills at issue today, and I appreciate all of your advocacy and great ideas to make this even stronger, and sharing why this is so important to move on. And thank you also for the work that many of you do in this space. There being no further business before the committee today, we are going to wrap up. The time is now